You went to a lawyer and you said you had financial troubles, and your attorney said to you, you can do a Chapter 7. So you come to a fee agreement and you come down to the time of filing, and your lawyer says, we have to change plans. You need to do Chapter 13. Why might that be? Hi, my name's Scott Goldstein. I'm the owner of the law office of Scott J. Goldstein. I'm a bankruptcy attorney. A lot of my other videos are going to have me in my office looking a little more professional, but this has been floating around in my head for the last couple of days, and I wanted to get it on video, and then I'm going to post it, and I want it to just come directly from me to you guys, to whoever's watching, because I think this is something very important to understand. When making a determination about what chapter to file in bankruptcy, there are a lot of factors that you need to take into account. The first one that most attorneys do is an equity consideration. What do you own? What do you owe on it? And how's that going to affect your case? The next issue is, how much money do you make? Do you pass the means test? Does that mean, and that means, do you basically, for your household size, make more money or less money than the rest of the people around you? And that's going to be based on an initial review, based on your gross income and a couple of major factors like whether or not you have a mortgage, alimony, things like that. Deductions that you can take off of it. The next thing is going to be, what's your budget roughly look like? Now, on an initial consultation, the attorney's not going to have the full story from you, and your situation may change. So, for example, I have a couple of clients that took a little while to get their cases ready to go because of either residency issues, fee-paying issues, a basic inability to get me their documents, things like that. And when that happens, when time passes between when the attorney does the initial consultation and you eventually getting to filing your case, things are going to change. In one of my clients' cases, a new income source suddenly popped up that, while still unable to pay her basic bills due to her income stream, even with this extra income, it affected her in such a way that she could not file for Chapter 7 because she was so over the median. Another case, the amount of income to expenditures, even when taken to the outer limit of reasonability for an individual with his situation, meant that I could not file a Chapter 7 case for that client because we would face several issues, including potential motions to dismiss. So I want to go a little bit to the side on this and tell you about the law on this. So when you determine whether or not you want to file for Chapter 7, this is governed by considerations under 11 U.S.C. 707, which is the section governing dismissal or conversion of a Chapter 7 case. The trustee can dismiss for cause if you file in bad faith or it's abuse of the system. And an abuse of the system is developed under a couple of different grounds. The first and the most standard is what's called the means test, which is, like I said before, based upon your gross income for your household size of all income streams. You take that, you multiply it by 12, you divide by 2, essentially. You average it out and multiply it and do some other magic math, and you come up with a number called the current monthly income. And your current monthly income for your household size needs to be under a certain number depending on your state. And if you're over median, you have to do a little mini tax return to see if you can get under an abuse threshold, which means you need to have less than about, I think it's $197 a month left over once you do this in order to qualify. That's the basic numbers. It's a little more complicated, but it can be, that's kind of the basics. If you don't pass under means test, you can't do a 7. Period. End of story. Very sorry to tell you this, but the numbers are the numbers and the law is the law. Now, there is a bit of wiggle room on the next part, which is the income and expenditure analysis. So what we do is we take your budget, which is your income, salary, unemployment, food stamps, child support, however you get money, we need to see it all, and we take it all, we put it into a schedule, and we look at what's your income. And then we look at your gross, we take away all your deductions, and we say, here's your net. Now, from that net income, we then look at your budget, which is, what do you spend to live every month? Housing costs, food costs, clothing costs, personal care, that means haircuts and nails, Bit of recreation, because no one expects you to sit in your house and twiddle your thumbs for your whole life. Car insurance, life insurance, health insurance, all these different things that you spend every single month to live a basic lifestyle. Now, I'm not talking luxuries. I'm talking a normal person's lifestyle, where you go to work, you come home, you do your thing, you make dinner, you go out occasionally to the movies, you go to the store, you buy what you need, you get new clothes, you get a couple of luxuries every once in a while. No one's telling you need to live like a Spartan monk or an ascetic lifestyle, but there's limits. So if your lifestyle involves monthly dinners at Ruth's Chris, that's not going to fly. An occasional dinner at the diner, definitely within the realm of possibility and reasonable. If your car payment is, if you've got a car payment, it is what it is. Even if you really couldn't afford the car, you bought it, you're stuck with it, you pay the car bill. Just what it is. But if you are giving 45% of your income to your church, trustee might have an issue with that. Things like that. Now, we look at your income and we look at your expenditures. We then try to figure out, we take out all of your debt payments. Why do we take out your debt payments? Because if you're filing for bankruptcy, you're not paying the debts. You're not paying the credit cards. You're not paying the medical bills that are past due. You're not paying the personal loans. You're not paying the payday loans. All that stuff goes up in smoke. So when I look at that, what is the number like? And when I look at that, I have to look very carefully, because if you have too much excess income to expenditure, so you've got money left over after you don't pay your bill, after you're not paying the credit cards, if you've got too much left over, then you're going to end up in a 13, because there is a provision, 707B3B, a totality of the circumstances analysis, where the U.S. Trustee's Office will look at your numbers and say, this person, with all their income, even with their spouse maybe paying their own separate bills if they're not filing together, now we got a problem. And why is that? Because this person's got $600 left over once they're no longer paying their credit card bills. Now, mind you, those credit card bills could cost $2,000 a month, which puts you negative $1,400 when you're paying them, but you've got $600 left over then once you're not paying your credit card bills. And that analysis is something that cannot be seen until the actual petition is prepared and the client provides all of their information. And I will tell you now, I have done thousands of consultations. I have very, very rarely, like 1% of my time, had clients provide me with all the information that I will glean from their documents at the time of the consultation. And the reason for that is you don't know what I'm looking for when I talk to you. And no matter how hard I try, I can never extract all the information from everybody when I do the interview. In the limited time an interview is going to take, and the limited time the consultation is going to take, there is almost no way to get that full analysis. And people don't know what they spend. I have met with thousands of people. No one knows entirely what they spend, and that is a thing that will come out when I review their when I review their petition, when I review their documents, when I review the bank statements, and I see, you're spending X number of dollars on whatever random thing it is. I had a client once where I had to have a real conversation with her about letting her niece or some other young child have access to her iTunes account, and charging hundreds of dollars a month on stupid little pay-to-play video game, free to play but freemium video games, and there were hundreds of dollars a month coming out for gem chests or whatever that stuff is that the kids like. So when you hire a bankruptcy attorney and the initial retainer is for a Chapter 7 and you want to get that relief desperately, most of us would rather put you in that Chapter 7 if we can. I would much rather have a client be in a Chapter 7, but the analysis that I have to do as your attorney would say that if I can't put you in the 7, let me get you some kind of relief at least, so that way, even if you're stuck in a 13 for a while, you still get most of your debt relieved, and you save thousands and thousands and thousands of dollars of interest. This is not a thing that we want to do, but it is a way the code is written, is the way the bankruptcy code is drafted, and as it is applied. Because the last thing I want to do is say, all right, let's do the 7, even though you've got, $400 left over a month. Let's see what happens, roll the dice. Because what's going to happen is that the U.S. Trustee's Office is going to review this thing on a second look, or your case trustee is going to review this, and they're going to say, you have to, and they're going to pass it up the chain. And then it's going to be a very unpleasant conversation between me and a trial attorney at the U.S. Trustee's office to say, well, here's why. And they're going to turn around and they're going to say something to the effect of, you have 2 weeks to decide with your client if you want to convert this case, or we're going to file a motion to dismiss for an abuse of the system. And that's going to end up with a motion to convert or dismiss. And I will guarantee that unless you have an incredibly good reason why your expenditures are not accurate or we can't fix your budget, if you just have too much money left over, you're going to end up getting converted to a 13. It is far cheaper to just give in to the inevitability in some cases and just say, all right, let's convert this case. Let's make it a 13 before we even go ahead and just do it. Chapter 13 is not the end of the world. It may be the best thing, but I did want to give an insight into the reasoning when an attorney will say to you, even though you said, yeah, Chapter 7, let's go, why that attorney will then turn to you and say, change of plans, here's why we have to now go in this new direction. This is a really long post, and I do hope it was informative. If you have questions, check out my website. I'm going to be posting more videos like this, so please keep an eye on my YouTube feed. I may even put some of this stuff on TikTok. I don't know. But please take a look at some of the materials we're going to be putting up over as the weeks go on. And I hope I'm going to be able to provide some informative information to you if you are having financial trouble to decide what your best option is, because this is the kind of stuff that you really need to know when you're consulting with an attorney or when things shift direction, because the law is fluid. My name's Scott Goldstein. I'm the owner of the law offices of Scott J. Goldstein. Check out my site. Check out my Facebook page. Check out my blog, and hopefully this will help you.